What happens when the person in charge of an estate isn't doing what they're supposed to do? Maybe they won't communicate with the family. Maybe important bills aren't being paid. Maybe assets seem to be disappearing. Or perhaps you're starting to worry that the executor is putting their own interests ahead of everyone else's. If you found yourself asking, can an executor be removed? The answer is yes, in certain situations. But removing an executor isn't as simple as filing a complaint because you disagree with their decisions. The probate court takes these situations seriously, and there's a legal process that must be followed. I'm Anna Burr with Burr Law, and in today's video, we're going to talk about when an executor can be removed, how the process works, and what Colorado families should know if they believe an executor is not fulfilling their responsibilities. If you're dealing with probate in Aurora, Centennial, or the Denver metro area, this information can help you better understand your options. Let's dive in. Before we talk about removing an executor, it's important to understand what an executor or personal representative in the state of Colorado is actually supposed to do. Many people are surprised to learn that being named executor isn't just an honorary title. It's a big legal responsibility. The executor has a fiduciary duty to act in the best interest of the estate and its beneficiaries. That means they're expected to gather and protect estate assets, notify creditors, pay legitimate debts and expenses, keep accurate records, follow court requirements, communicate appropriately with all the beneficiaries, and distribute assets according to the will or Colorado law if there is no will. In other words, the executor is responsible for managing the estate honestly, responsibly, and transparently. Most executors are family members who are doing their best during a difficult time. They are also grieving, and they have this added responsibility on top of all of that. But sometimes problems arise. And when they do, families often wonder whether the court should step in. One of the biggest misconceptions people have is that an executor can be removed simply because family members don't like them. And that's usually not enough. Probate always involves emotional situations. When family members may disagree about when or whether to sell a house, how property should be divided, how quickly the estate should be moving forward, decisions involving repairs, maintenance, expenses. Disagreements alone won't justify removal. The court understands that executors sometimes have to make difficult decisions, and that is what the court has tasked them to do. The key question is not whether everyone agrees with the executor, it's whether the executor is fulfilling their legal duties. So what kinds of situations can lead to a successful removal? Let's look at one of the most common examples, which is neglect of duties. An executor may be removed if they simply aren't doing the job. This could be failing to file the required probate documents, ignoring court deadlines, not paying estate obligations, allowing estate property to deteriorate or be vandalized, failing to administer the estate for an extended period. When estates sit stagnant for months or years without good reason, courts become concerned. The second way an executor could potentially be removed is for mismanagement of the assets. Executors have an obligation, a legal responsibility to protect estate property. If they're wasting assets, making reckless decisions, or failing to safeguard property, then removal may become necessary. This could be allowing insurance policies to lapse, neglecting a vacant property, failing to secure other valuable assets, or making unauthorized transactions. You can't use estate assets to do things like pay your own Netflix bill. The third reason an executor could be removed is for conflict of interest. Executors have to act for the benefit of the estate, not themselves. And often an executor wears two hats, both as the executor of the estate and as an heir of the estate. If the executor is a family member, then this happens a lot, and they have to be careful to keep those two roles separate from one another. When personal interests interfere with the duties of the executor, then problems can arise. They might favor themselves over other beneficiaries. They might withhold information or manipulate distributions, or they could use estate assets for their own personal benefit. These situations can create significant concerns for the court. Number 4 is through fraud or misrepresentation. This is one of the most serious situations, but also generally the most rare. This is where an executor is stealing from the estate, hiding assets, falsifying records, or diverting funds for personal use. And if that's happening and there's proof of it, the court can remove them and impose additional legal consequences. The 5th basis for removal is incapacity or unavailability. Sometimes removal isn't about wrongdoing at all. An executor might become very ill, they might become incapacitated, they might simply disappear or be unable to perform their responsibilities for other reasons. When that happens, the court may appoint someone else to ensure the estate can move forward in a timely fashion. If you believe an executor should be removed from a probate estate, what happens next? Well, the first step is to file a formal petition with the probate court in the county where the family member who died lives. This is a legal request asking the court to review the executor's conduct. This petition generally outlines what the executor has done or failed to do, why those actions violate their duties, and evidence supporting those claims. Once the petition is filed, the executor has an opportunity to respond. The court then reviews the information provided, and depending on the circumstances, the judge might request additional information, schedule a hearing or a trial, or may order the parties to go to a mediation and try and work things out themselves. The court's goal is to determine whether removal is truly necessary to protect the estate and the beneficiaries. This is where many people make mistakes. Families often come into probate disputes with understandable frustration. They feel ignored, suspicious, or just that something isn't quite right. But courts don't make decisions based on feelings. They rely on evidence. So strong evidence of wrongdoing might be based on financial statements, bank records, accounting discrepancies, missed deadlines, outright violations of court orders, written communications, property records, or other documentation showing a lack of action. The stronger the documentation, the stronger the case. If you believe an executor is acting improperly, it's important to preserve records and gather facts before taking action. If the court determines removal is justified, the estate doesn't simply stop. Instead, a replacement will be appointed. Sometimes the will names a backup executor, and if so, that person may step into the role. If no alternate is available, the court may appoint another qualified individual to administer the estate. The replacement executor takes over the responsibilities and continues moving the probate process forward. The court's primary concern is ensuring the estate is administered properly and beneficiaries and creditors are protected. The best solution to this is often prevention. When creating an estate plan, many people spend a lot of time deciding who receives their assets, but they spend very little time deciding who should manage the estate. Choosing the right executor is one of the most important decisions in the entire estate planning process. Look for someone who is trustworthy, organized, responsible, communicative, financially competent, and most importantly, willing to handle the job. Being the oldest child doesn't automatically make someone the best choice. Being the closest relative doesn't automatically make someone the best choice. The right executor is someone who can remain calm, organized, and fair during what is often an emotionally difficult time. If you are concerned that an executor is not fulfilling their responsibilities, don't ignore the warning signs. Executor misconduct can create delays, increase expenses, damage family relationships, and jeopardize estate assets. The good news is that probate courts have procedures in place to address these situations when necessary. And if you're creating your own estate plan, Taking the time to choose the right executor now can help your loved ones avoid significant stress later. At Burr Law, we help Colorado families navigate probate challenges, resolve executor disputes, and administer estates with clarity and confidence. You don't have to go through probate alone. If you have questions about an executor or personal representative, or any aspect of the Colorado probate process, we're here to help. Thank you so much for watching. And if you found this helpful, please be sure to like, subscribe, or share it with someone you care about. We'll see you next time.